Hello. In this lecture, we are going to discuss the various civil and political rights provided under the Universal Declaration of Human Rights. The civil and political rights form the original and main part of the international human rights. The civil and political rights are a class of rights that protects the individual's freedom from unwarranted infringement by governments and private organizations and ensures one's ability to participate in the civil and political life of the state without discrimination or repression. The civil rights includes first, ensuring of people's physical integrity and safety. Second, protection from discrimination on grounds such as physical, mental disability, gender, religion, race, national origin, age, sexual orientation or gender identity. Third, individuals' right of privacy. Fourth, freedom of thought and conscience. Fifth, freedom of speech and expression. Sixth, freedom of religion. Seventh, freedom of press. And eighth, freedom of movement. The political rights includes first, natural justice, that is the procedural fairness in law, for example, the rights of the accused. Second, the right to a fair trial and due process. Third, the right to seek redress or a legal remedy. Fourth, the right of participation in civil society and politics such as freedom from association. Next, the right of participation in civil society and politics such as freedom of association. Next, the right to assemble. Next, the right to petition, the right to self-defense and the right to vote. The civil and political rights are fundamental and basic human rights. They can be compared with the fundamental rights of the Constitution of India. Most of the civil and political rights of the UDHR have also been incorporated in the International Covenant on Civil and Political Rights 1966. These rights are covered under Article 2 to 21 of the Universal Declaration of Human Rights. The member states of these covenants are bound to follow these rights, which can be enforced in various countries. These rights are first, the prohibition of discrimination. The difference on any of the grounds mentioned such as race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other status normally evolves because of the lack of basic understanding of law and moral values of a society. It is through this provision of the UDHR the mechanism is provided to bring about the equality and reduce discrimination. The Article 2 of the UDHR says about this right. The basic aim of this right is to prohibit any sort of discrimination not only amongst individual but also amongst nation. There shall be no discrimination while dealing with various persons or nations. Whatever the type of government or territory, whatever the type of person, all should be treated with equality and respect. The right under Article 2 of UDHR have also been incorporated under Article 15 of the Constitution of India, which can be related with this provision of UDHR. The Article 15 of the Constitution of India is a fundamental right which prohibits the discrimination on the grounds of religion, race, caste, sex or place of birth. Further, Article 15 subclause 3 and subclause 4 also provides for making special provisions for the upliftment of the women and children and for the enhancement of any socially and educationally backward classes or for scheduled caste or scheduled tribes. Moreover, Article 17 of the Constitution also abolishes untouchability, making it an offence punishable by law. Right to life, liberty and security. This article is one of the briefest but most important for all human and for the UDHR. It implies that the international community and the states in their constitution have to take the responsibility to provide a life wherein the people meet their minimum requirements. Right to life has been reflected in religious texts across the world. The Article 3 of the UDHR says that everyone has the right to life, liberty and security of person. Article 5 of the United States Constitution provides that no person shall be deprived of life, liberty or property without due process of law. According to the United Nations Human Rights Committee, the right to life is the supreme right. These rights are considered as the foundation and cornerstone of all other rights. The right to life is recognized as a part and parcel of international law and which cannot be changed or restricted. As a general rule, human rights treaties consider that the right to life may never be suspended even in case of a national emergency or war. The right to life is also related to the economic, social, cultural rights such as right to food, right to medical care, right to education, etc. Depriving people of these rights would lead to depriving people of the right to life itself. In India, the right to life is guaranteed under Article 21 of the Constitution. The liberal interpretation given to the right to life by the Supreme Court of India has made this article one of the most important articles in the Indian Constitution, which includes within itself various other rights such as right to privacy, right to speedy trial, right to free medical aid, right to compensation, right to healthy environment, etc. The next article is prohibition of slavery. Slavery was an ancient practice which has been followed for generations together and is still practiced in different forms in various countries across the world. Currently, even in the modern era of globalization, slavery is practiced in various forms such as bonded labours, human trafficking, forced labour, etc. Therefore, this article prevents slavery and slave trade in all its forms. Article 4 of the UDHR says about this right. The United Nations, apart from prohibiting slavery, also adopted number of other conventions which prohibits prostitution, child trafficking, abduction, etc. This will help to prevent any kind of deprivation of life, liberty and security to human person in any form. The United Nations declared 2nd December every year as the Anti-Slavery Day. International law strictly prohibits states to practice any such practice that may lead to slavery of any kind. The International Court of Justice in the famous Barcelona traction case has regarded protection from slavery as included in the basic right of the human person, which give rise to obligations which states have to obey. Article 23 and 24 of the Indian Constitution prohibits all types of slavery and human trafficking in India. Moreover, the Supreme Court in various cases have recognized the evils of bonded labour and has awarded compensation to the victims of such practices. Next is prohibition of torture. Now, torture is another important factor in the violation of human rights. It has been inflicted through various ways and means, which includes physical, psychological, mental torture, etc. Torture is prohibited by international law of human rights also. The United Nations has adopted a convention against torture and other cruel, inhuman or degrading treatment or punishments, banning its practices in any form. Article 5 of the UDHR says that No one shall be subjected to torture or to cruel, inhuman or degrading treatment or punishment. This means that any inhuman, degrading treatment or punishment which leads to torture is completely prohibited and amounts to the violation of human rights. The Vienna Declaration and the Programme of Action 1993 has also condemned torture in unequivocal forms. To prevent torture, the United Nations constituted a committee to monitor the implementation of the convention and makes recommendation to be followed by various states. In recent times, international agencies like the World Bank and the International Monetary Fund have incorporated practices of torture as one of the grounds to refuse loans to countries. Next is right to recognition as person before law. This right means that any person, irrespective of his nationality or background, has certain inherent human rights that are recognized universally. Article 6 of the UDHR says that everyone has the right to recognition everywhere as a person before the law. This article can be correlated to the Charter of United Nations, which starts with the phrase, "We the people of United Nations," which clearly implies that all persons are same and equal in the eyes of law. In order to achieve equality before law, a state is entitled to extend any concession to any group of people depending upon various factors. The article is applicable to both citizens and non-citizens of a nation. Similar provisions have been laid down in Article 14 and Article 21 of the Constitution of India, which guarantees equality and right to life to all persons and not merely to the citizens. Equality before law. All persons are equal in the eyes of law. At times, in order to promote the rights of certain weaker sections or vulnerable groups like women, children, disabled, minorities or people belonging to various social groups, certain steps needs to be taken for their development. This does not amount to the discrimination, but it can be termed as protective discrimination. Article 7 of the UDHR deals with this right. This article can also be correlated to Article 2 and Article 6 of the UDHR. This means under no circumstances, whatever may be the status of a person, can a person be discriminated against. Article 14 to 18 of the Indian Constitution guarantees equality before law for all persons and provide for specific measures for upliftment of weaker sections of society, which is applicable only to the citizens. Therefore, it becomes the duty of the international community to implement the spirit of international law in order to achieve universal brotherhood. Next is the right to an effective remedy. Now, this lays a responsibility upon the state not only to protect the fundamental human rights of a person, but also to provide for adequate judicial remedies to enforce such fundamental rights. Therefore, there should be constitutional guarantee and safeguards in every state which individuals can avail of as a matter of right by approaching the competent court. Taking into consideration the various human rights violations carried out in various states, the General Assembly of the United Nations in 2005 adopted a declaration with a set of principles and guidelines to be followed by states in protecting the rights of victims of violations of human rights. In India, effective remedies for violation of fundamental rights are guaranteed under Article 32 and 226 of the Indian Constitution. Article 32 guarantees every citizen the right to move to the Supreme Court for the enforcement of fundamental rights. Similar powers are given under Article 226 to various high courts across the country. Moreover, the scope of Article 32 and 226 has been widened considerably by the Supreme Court through Public Interest Litigation Movement or PIL. Prohibition of arbitrary arrest. Now, according to this, no person can be arrested on suspicion or imprisoned or exported or taken away to an undisclosed location without the knowledge of the judiciary. Article 9 of the UDHR says that no one shall be subjected to arbitrary arrest, detention or exile. The article also guarantees an individual's freedom from abuse of power from government authorities such as police while applying criminal law. The article also includes taking person into preventive detention or custody. Preventive detention means taking a person into police custody to prevent him from doing a crime. There is an obligation upon states and the international community to prevent any misuse of power, especially that of detention. It is a general rule of international law and it needs to be obeyed under any circumstances. Violation of this right leads to the violation of various human rights such as freedom of movement, freedom of speech, freedom of life and freedom of liberty. In India, the Constitution under Article 22 guarantees such rights as a fundamental right. The next is right to fair trial. The concept of fair public hearing is basically natural and inherent right based on the principle of a term known as natural justice. Every person has a right to defend himself in the court of law, that is what we say impartial tribunal, either by himself or with the help of lawyer. The trial can be therefore first infringement of rights, second for illegal obligation and third for criminal charges against him. In India, the concept of fair trial is a part and parcel of right to life guaranteed under Article 21 of the Constitution of India. The importance given to the principle of fair hearing has been laid down in the passport case, that is Maneka Gandhi versus Union of India, wherein the Supreme Court has recognized the opportunity to be heard of as a basic and inherent right, presumption of innocence and no retroactive application of penal laws. Now, this right under this article is the basic principle of criminal justice which is practiced across the globe. It can be seen under 4 headings. First is presumption of innocence. No person shall be treated as guilty until and unless it is proved that he is guilty by a court of law. This is why many countries across the world have provisions of bail which entitles a person to be released from custody with certain terms and conditions until he is proved guilty by the court of law. Next is the right to defense. Now, this word guaranteed in this article means that any person charged with any offence has freedom to defend the case until the crime is proved and finalized by the highest court of the country. In India, the right to free legal aid has been given the status of fundamental right and therefore, it becomes the duty of the state to provide legal aid to the poor and needy persons. Third, right to public hearing. This has been developed on legal saying that justice should not only be done, but should be seen to be done. Therefore, a person should go through a proper trial before convicted by the court of law. An absence of such right would result in gross violation of human rights. Fourth, non-retroactivity of law. According to the second clause of this article, a person can only be punished for an offence which was an offence at the time of the commission of that act. If later any new law is introduced, it will not be applicable to such a person. In legal terms, this is known as the retrospective operation of laws. In India, such rights are found in Article 20 of the Constitution. Article 20 is applicable to both citizens as well as non-citizens. It serves as a restriction on the legislative power of the Parliament or the state legislature not to misuse any power during the making of laws. Conclusion. In this lecture, we have discussed the Article 2 to Article 11 of the UDHR, which are the civil and political rights. The importance of civil and political rights cannot be ignored